announcing legislation to take sexual misconduct investigations out of the jurisdiction of the military justice system, moving those cases to civilian courts and police forces. It was one of the key changes recommended by former Supreme Court Justice Louise Arbour in her 2022 investigation into sexual misconduct in the military. Defense Minister Bill Blair is with us now. Hi, Minister. Good to see you. Thanks for making the time.
Of course. Thank you very much for having me, Vashi.
I wanted to start off by asking you about the timing of this. As we mentioned, Justice Arbour did say back in 2022, almost a full 2 years ago, that this was a central recommendation from her. I heard you today tell reporters that there was a lot of consultation done in the interim, but Justice Arbour also based her conclusions on a lot of consultation. Can you sort of succinctly describe for Canadians watching tonight why it took you 2 years to table this legislation?
Well, Madam Justice Arbour, in her own report, indicated that the changes she was recommending could take several years to implement. I've been in regular consultation with her, and we've also established an external monitor. But the Canadian Armed Forces has been consulting with members of their own service, but also with victims, with survivors, and with advocates. We've worked very, very carefully and closely with our Judge Advocate General, but there's also been extensive consultation with police services across Canada, with Solicitor Generals and Attorney Generals from the provinces and territories. All of that was, I believe, absolutely necessary to make sure that we got the legislation right. But today we have tabled Bill 66. It's an act to modernize the military justice system, and it responds very precisely to the recommendations Madam Justice Arbour made. It also deals with a number of other recommendations, for example, the independence of some of the judicial actors involved in these investigations and in military justice system. All of that work is we identified. Madam Justice Arbour made 48 recommendations to us. We have been working very hard in the implementation of all of those recommendations, but her recommendation 5, taking these cases from the military police and the military justice system and putting it in the civilian police and justice system, required legislative changes, a change to the National Defence Act. We brought that legislation forward. I will tell you, we intend to work hard to get that legislation passed as quickly as possible.
And I want to ask about that part in a second, but just on sort of what this affects and to what degree. I know that your predecessor, Minister Onnet, had issued a directive to this effect, that newer cases that were filed or newer complaints that were filed did go through the civilian side. Does this retroactively apply to anything prior to that, or are those cases stuck in the military justice system?
No, we have some cases that are still in the military justice system, and one of the challenges we face there, Vashi, is because the charges were laid, for example, in the military justice system. For us to transfer some of those cases into the civilian justice system would require the laying of a new information, but it could result in what the court could determine to have been an unfair delay in that process. And therefore, we're working very closely with the Judge Advocate General, but also with the civilian justice system. We want to make sure that we can get justice for the victims of sexual assault. We're working very closely with those victims. There are some challenges we're facing, but on a going forward basis, first of all, all new cases have been referred to the criminal justice system. Yeah. In the civilian criminal justice system, and this legislation will institutionalize that change, set it in law, and once it becomes the law of the country, I think it'll resolve a lot of the uncertainty that victims have faced.
So what about those other cases, though, that you mentioned? Can you quantify for us? I think you said today 150 have been referred since December of 2021 to the civilian side. How many remain sort of in that problematic position of not being able to do that without risk?
Well, there is some process taking place with approximately 100 other cases. But again, all new cases, since Minister Anand issued her directive, all new cases have been referred to the civilian criminal justice system. And we're working through and have been over the past few years to make sure that all of the existing cases are dealt with appropriately. This legislation, I think, will provide the clarity and the certainty of how these matters are to be dealt with. And I think it's also clarity that civilian police services across Canada and our attorney generals in the provinces and territories require in order to make this change institutionalized and permanent.
You said, Minister, that you had spoken to your critics, defense critics, in the other parties. I wanted to drill down on your anticipation. I know you can't predict exactly the way this will go, but based on those conversations, do you expect the Conservatives to support this?
What I expect is every member of Parliament will understand the importance of this legislation. There has been robust discussion about the challenges of the investigation of sexual assault and harassment charges within the Canadian Armed Forces. I have every expectation. Frankly, I know my critics very well. I think they all care about the Canadian Armed Forces. They want to do what is right and what is necessary to make sure that every member of the Armed Forces, men and women right across this country, and everyone who would hope someday to join the Armed Forces, they deserve a respectful, supportive, and safe work environment. I know we're all committed to that. We have some work to do, and I have great respect for parliamentary processes. I'm hopeful that we can get this bill in front of committee. They've got important work to do, witnesses to hear from, and advice to provide. And as I've tried to make it very clear today, I respect those processes, and I will work very closely with my critics who wish to strengthen the bill. I do not intend to entertain any motion that would weaken the legislation.
Okay, Minister, I know your time is limited tonight, so I do want to ask you a few questions on the federal government's position, the Canadian foreign policy as it relates to military exports to Israel. What was passed and defined in the NDP opposition motion a few days ago in the House of Commons, will that be Canadian foreign policy, aka is there an explicit ban on all lethal and non-lethal military exports to Israel?
Yeah, let me be very clear. First of all, Canada has a long-standing, existing regime for export permits, which is managed by Global Affairs. It's one of the strongest in the world. And under that regime, since January the 8th, well before the resolution, no new permits, export permits, have been issued by Global Affairs for the export of any military equipment to Israel. All permits that were issued prior to January 8th will be respected and proceeded with. But Global Affairs has made it very clear that any new permit would only be approved if it met the rigorous requirements of our existing regime. And since January 8th, no new permits have been issued.
So does that mean that there is no tangible change in the way your government is approaching this? Because there's two separate things. There's an edict that can be issued according to the NDP's motion that is, we're not doing this, no way, no how. And then there's a system that's in place based on evaluation of whether or not export permits should be applied or should be approved. If it's the latter, then there's some time in the future, even during this war between Israel and Hamas, in which an export permit could maybe meet the requirements and be approved. If it's the former, and it's what the NDP is saying, that's not ever going to happen.
Can I be very clear? We have a very rigorous existing process of permit approval that is already in place. Since January the 8th, GAC has determined that there has been no new permits issued, and there will be no further permits issued until they are satisfied that any new application will meet the rigorous high standards that already exist in our export approval regime.
And so is the NDP writing your government's foreign policy? That is what the Conservatives are accusing your government of.
Well, let me be very clear. Well before this resolution, Canada has said that Israel has a right to defend itself. We have said that Hamas is a terrorist organization. We've called for a humanitarian ceasefire, but we've also called for Hamas to lay down their arms and to return all hostages. And finally, it's been a very long-standing policy of the Canadian government that we support a negotiated two-state solution that would recognize the security requirements of the state of Israel. And so there has been no substantive, and frankly, that's long-standing, existing government policy, which was entirely consistent with the actual wording of the motion that came forward last week.
Will Canada continue to import military goods from Israel? I read a media report in that country that assessed the value in the last decade of those imports north of $1 billion. Does your government, and do you as minister who oversees the Defense Department, intend to continue importing military goods from Israel?
Yeah, first of all, we will always comply with the legal requirements. I have a responsibility to get the best possible equipment for the Canadian Armed Forces. And so I do not require, and CAF does not require an export permit because this is an import from another country. That regime is managed in a very different way and is not impacted by Global Affairs' very rigorous export permit regime.
Sure, but the reason I'm asking, Minister, with all due respect, is we're talking about your government's posture towards the government of Israel. The reason those export permits are not being approved is because there is some concern among a department in your government that that the military goods you're exporting are being used for nefarious purposes by the government of Israel.
No.
Are you okay
and again,
no, but that's, I mean, there's a reason that they won't be approved. So just let me finish my question if you don't mind. If that is in fact the posture of your government, then why is it okay to import military goods from a country that you feel is acting in a way that is not conducive to sending our own military goods to? Is that intellectually consistent?
Well, with all due respect, Vashi, what I've said is and you're ascribing motive that I did not articulated to you. And in fact, what I've said is we will not be issuing permits until we are satisfied that they will meet the very rigorous approval requirements that is already in place with our existing export permit regime. And with respect to importing goods, again, my job is to make sure that we get members of the Canadian Armed Forces and Canada the very best possible tools that they require to defend their country. And they're two very different discussions. And again, the motive for our existing export regime or in those applications was not as you described.
So what is it then, Minister? Because I think Canadians are sitting at home wondering, okay, why won't we export military goods to Israel? I know you're saying there's a process, but what is under consideration then to deny that export permit? Would it not be what those military goods are being used for, or questions around what they're being used for?
And again, our very rigorous export permit regime for military equipment to any country in the world has requirements on and assurances on how that either technology or equipment, either lethal or non-lethal, might be used. And
Sure.
Until we are satisfied that those applications meet those rigorous high standards, we're not going to approve them. And at the same time, if there is equipment that, and to the converse of your other question, if there is equipment that the Canadian Armed Forces needs, and this is the best equipment after a rigorous procurement process that we undertake to acquire what the members of the Canadian Armed Forces need to defend our country, then we'll continue with those contracts.
Even if it comes from a country that right now your government does not feel comfortable sending military goods to?
No, and to be very clear, we're not going to send military goods to any country until we are satisfied that those military goods will be used in a way which satisfies the rigorous requirements of our existing regime.
So it's not Israel per se, it's just the regime.
It's the rules, Vashi. We're making sure that we're upholding and following our own rules. As I said, we have one of the most rigorous export permit regimes for military equipment of any country in the world. We're making sure that we follow our own regime and that any country seeking to import any equipment or technology from Canada meets those rigorously high standards.
Okay, Minister, I'll leave it on that note. I appreciate your time as always this evening. Thank you.
Of course.